Hello friends, today's lecture is on judicial responses to protection of rights of minority. The Indian Constitution does not define the term minority, nor does it lay down sufficient indicators for the determination of a group as minority. Framers of the Indian Constitution made no efforts to bring it within the confines of a formulation. Even in the face of doubts being expressed over the advisability of leaving back justifiable rights to undefined minorities, the members of the Constituent Assembly made no attempt to define the term and presumably left it to the wisdom of the courts to supply the omission. This is given the fact that the Indian judiciary has wide powers to interpret the Constitution and to nullify acts of the legislature when these are judged as violating the Constitution. In this lecture, we make an attempt to describe how the judiciary has responded from time to time to safeguard the rights of the minorities. Now let's move on to judicial view on minority. The initial courtroom attempt to answer the first question was made in the Kerala Education Bill, where the Supreme Court, through S.R. Das, suggesting the techniques of arithmetic tabulation, held that minority means a community which is numerically less than 50% of the total population. This statistical criterion prevailed with the Kerala High Court also, which in Aldo Maria Patroni versus CEC-UGC 1963 defined minority to mean the same thing as it meant to the Supreme Court. Religion and language are the criteria indicated in Article 30, a precondition for the latter acceptability. The Constitution itself tends to confine the tasks of the courts to the ascertainment whether the group claiming constitutional protection is the group identifiable by the characteristics of religion or language and is numerically non-dominant. The courts have therefore only to be sure for themselves that the basis of claim to protection is either religion or language. Interpreting the words based on religion, in Article 30, the Delhi High Court in 1975 pointed out that the words would mean the only or the principal basis of the minority must be their adherence to one of the many religions, and that the other features of the minority are subordinate to the main feature, namely its separateness because of the religion. A similar interpretation can also be placed on the words based on language. Thus, for the purpose of Article 30, a minority means a non-dominant collectively distinguishable from the majority of population by the objective factors of religion or language or a combination of both. Now let's move on to Supreme Court principle, state-specific minority. In the 2002 judgment in TMA Pai Foundation and others versus the state of Karnataka and others, the Supreme Court deliberated on the various contentions that the center, the state, or a particular region within a state may be considered as the basic unit for protection of the right of minorities to set up minority educational institutions, and whether a minority in a state would lose its minority status if within a particular region of the state it happened to be in a majority. The court has set out the principle that minority status should be determined in relation to the population of the state and not to India as a whole. It ruled that as the reorganization of the states in India had been effected on linguistic lines, for the purpose of determining a minority, the unit would be the state and not the whole of India. Thus, religion and linguistic minorities who have been placed on a par in Article 30 have to be considered in terms of the state concerned. This issue surfaced again in Bal Patil 2004 and Srivastava 2007. These two judgments have further complicated the question of definition of minorities, as both these judgments relate for the most part to definitional issues. Bal Patil questioned the identity of Sikhs as a religious minority, while Srivastava ruled that Muslims, by the virtue of their numbers, cannot be considered a minority in Uttar Pradesh. The principal rationale for state-specific minorities rests on the idea that the linguistic reorganization of states necessitates that they may be treated as the basic unit for determination of minorities. As both linguistic and religious minorities are covered under Article 30, both sets of minorities have to be state-specific. The linguistic reorganization of states meant that for the purpose of Article 30, linguistic minorities had to be determined in relation to the state because their language was not one of the official languages. Other minorities are those whose mother tongue is an official language but who live outside the states where the language is official. According to Zoya Hassan, as regards religious minorities, linguistic reorganization should not really matter in the exercise of their right to set up educational institutions of their choice or seek admission in such institutions or the exercise of other minority rights. In comparison to linguistic minorities, for whom the official language matters, there is no congruence between religious identity and state boundaries. For protection under Article 30, linguistic minorities make claims upon the states rather than the center. But this need not be so for religious minorities who are dispersed throughout India and whose identity is not linked to specific states. In this context, defining minorities at the state level would limit the notion of minorities, entailing as it does the adoption of an essentially statistical conception of minorities. Thus, a religious group which is numerically smaller than the rest of the population of the state to which it belongs would be entitled to be termed a minority in that state, even though the group may be numerically in a majority in India as a whole and hence not lacking in power or voice in the decision-making structures. This will doubtless add to the list of minorities and extend the benefits of minority entitlements to these groups, even as it will deny the same benefits to groups that are minorities in accordance with nationally and internationally accepted definitions of minorities. Now let's move on to minority educational rights and the Supreme Court. The Indian Constitution granting minorities the right to establish and administer educational institutions came into effect in January 1950. Much of the law on minority educational institutions in post-independence India has been a product not of centralized legislation but the court's rulings on numerous, sometimes disconnected cases. The framework for the recognition of minority educational institutions prepared by the National Commission on Minority Educational Institutions (NCMEI), formed in 2004, is based largely on and refers explicitly to the judgment of the Supreme Court. Minorities have the right under Article 30, Clause 1 of the Constitution to establish and administer educational institutions of their own choice. These institutions, commonly referred to as minority institutions, have been defined as a college or institution other than a university established or maintained by a person or group of persons from amongst the minorities by the NCMEI Act. These include schools, colleges, and professional training institutions. This right has been the subject of many court cases and shrouded in several controversies such as the Kerala Education Bill case 1958, the St. Xavier's case 1974, the St. Stephen's College case 1992, and the TMA Pi case 2002. The Pi case was followed by the Islamic Academy case 2003 and the Inamdar case 2005, both of which claimed that their purpose was the clarification of the Pi case. Most of the cases have been structured by two central questions. First, does Article 30, Clause 1 mean that the government cannot intervene in the management of minority educational institutions? Second, does Article 29, Clause 2 require that minority institutions must be open to all citizens, or does Article 30, Clause 1 concede that they can reserve seats for members of the administering community? The Kerala Bill case was an advisory opinion issued by the court on the request of the President, who wished to inquire whether a bill presented to him for assent was in accordance with the Constitution. The bill passed by the legislature of the state of Kerala gave sweeping powers to the government to regulate as well as to take over educational institutions, including those run by the minority in case of mismanagement or in public interest. The court ruled that the protection under Article 30, Clause 1 meant that the government could not take over minority institutions, but regulatory measures by the government were permitted. It also laid down that aided minority institutions would need to admit a sprinkling of outsiders to comply with Article 29, Clause 2 of the Constitution. A similar issue confronted the court in the Xavier's judgment, where the legislature of the state of Gujarat passed a bill giving similar powers to the government, which were challenged by a Christian minority college. The court ruled in favor of the college and restricted the scope of permissible governmental regulations that were allowed in the Kerala Bill case. However, it affirmed the Kerala Bill case position on the need for minority institutions to admit a sprinkling of outsiders. In the St. Stephen's case, the issue of preferential admittance of members of one's community by a minority institution was raised explicitly. Two Christian minority colleges, St. Stephen's College and Allahabad Agricultural Institute, argued that the admission policies of their respective universities did not apply to them since they precluded such preferential admission and imposed a uniform system of selection upon them. The court again ruled in favor of the institutions but limited the scope of preferential admittance to 50% of the available seats. With regard to governmental regulation, it affirmed that though the government could lay down minimum qualifications for candidates, minority institutions could follow their own method for the selecting students instead of following the method determined by the public university they were affiliated to. The Pai judgment is one of the most significant judgments on minority educational rights in India, presided over by 11 judges. The court affirmed inter alia the minority's right to admit students preferentially, while removing the upper ceiling prescribed in the St. Stephen's case. It also laid down the principle that government could intervene in minority institutions to a reasonable extent insofar as such intervention did not destroy their rights under Article 30, Clause 1 of the Constitution. The Islamic Academy case involved essentially a clarification of the judgment in Pai. However, it was widely seen as having complicated the jurisprudence on minority educational rights further and resulted in another round of clarification subsequently in the Inamdar case. In both cases, the controversy has mostly revolved around what constitutes a reasonable intervention and what counts as violating the minority's right under Article 30. The court's stand on minority educational rights has been intermediate as well as indeterminate. The court's judgment have been unable to, by its own admission, settle the law. On the issue of governmental regulation versus minorities' right to administer, the court has attempted to synthesize both by arguing that government regulation in minority educational institutions is allowed insofar as it does not destroy the minority character of such institutions. But it remains unclear what intervention counts as reasonable and what counts as destroying an institution's minority character, with the permissible scope shifting across the judgments. On the issue of individual non-discrimination versus minorities' right to preferentially admit their own students, the court has again taken an intermediate position, allowing for preferential admission but only to a limited extent. However, the extent to which such preference may be given is indeterminate, and is to be determined contextually by different state governments based on variable factors. Now let's move down to conclusion. The concepts of democracy, justice, secularism and concern for national unity, which in many ways hostile to a more explicit and extensive regime of group rights, have influenced the court judgments regarding minority rights in India. However, the Supreme Court's approach too is one of the striking balance, though the extent of the balance remains unclear. The Supreme Court often holds conflicting understandings of the same concept, with each playing a role in its intermediate and somewhat ambiguous stance on minority rights. For instance, democracy is conceptualized in a majoritarian manner, which is in opposition to group rights. At the same time, the court simultaneously also speaks of democracy in terms of constitutional rights, which is more conducive to group differentiated rights. Further, the court also leaves adequate room for addressing problems contextually rather than through a fixed doctrine. The courts, however, seem to have been persuaded by practical compulsion rather than be swayed away by a feeling of faithfulness to the spirit, given that India is a diverse country where one holds the principle of unity in diversity. Thank you.